This is case number 41-173-595. This is Credit Acceptance Corporation versus Alexandra Lane. The matter is before the court on a motion to set aside a default judgment. The record should reflect in this matter that the judgment in this matter was entered by default on the 4th of March 2022 for $13,863.57. Subsequent to that time, the court did receive a motion to set the default aside. I took the motion under advisement and set it on for hearing on today's date. Your appearance for credit acceptance at this time, please.
Good morning, Your Honor. My name is Eric Naslund, Naslund, P42648, on behalf of the plaintiff.
Thank you, Mr. Naslund, and good morning to you, sir.
Good morning.
I'm looking now for Alexandria Lane or her counsel. If you're on the Zoom, Ms. Lane, say something at this time. Alexandria Lane. All right, the record should reflect that on March the 28th, the court did set this matter on for a hearing. And I did, looking at the notice now, indicating today's date and indicating this particular Zoom number. Have you spoken with Ms. Lane at all, counsel, today or anytime leading up to today, sir?
I have not, and the file materials do not reflect that she contacted the law firm Rusin, Varchetti, and Olivier.
Thank you, sir. Let's see what. Well, it looks like initially the motion was set for the 21st of April. It looks like at that time, I think that the plaintiff was not present, and I went ahead and set it for a different date. I think that's what happened. Let me just check and see.
Yeah, I'll wait on it. Oh, motion.
So I'm trying to see why I adjourned it from the April date, April 21st till today's date. In any event, Ms. Lane is not here, and even though this is her motion, she's not here. It was set for 9:45 p.m. Given that she's not here, I'm going to deny the motion.
Very good, Your Honor. Do we need to prepare an order, or do you have that with the recipe?
I did not get a proper recipe to do that with. So if you'll submit an order, that would be helpful, sir.
We will submit it, Your Honor, today. Thank you.
All right, thank you, sir. Good day to you. The court now calls case number 22-1776-93. This is Always On Time Transportation versus the city of Detroit. Matters before the court set for a scheduling slash status conference. The court has received the answer regarding this matter, and the matter has been properly joined before the court. There is a demand in the answer for compulsory joinder as well. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Karen Clark on behalf of the plaintiff, P number 74604.
Thank you, Ms. Clark, and good morning to you, ma'am. For the city of Detroit, your appearance at this time, counsel.
Good morning, Your Honor. Alfred Ashew, P82536, on behalf of defendant, City of Detroit.
All right, thank you, Mr. Ashew. Good morning to you, sir. All right, so it looks like things are just getting started here. Have you at all talked about this? Is it your position that the court should set this on for some discovery and take a look at it later on? Go ahead and talk to me, Ms. Clark.
We have not had an opportunity to talk. It does seem like a pretty routine matter, though, so I do believe that a scheduling order and some discovery would be appropriate. I'm sure the parties can have an opportunity to speak while they are conducting discovery.
All right, thank you, Madam Counsel. Mr. Ashew, anything at this time, sir? Go ahead.
No, I would agree with the plaintiff's counsel.
All right, very well. So I will go ahead and set a scheduling order in this matter. I will open discovery and extend it or allow it to continue for 60 days hence or until the next action date, which will be a pretrial conference date. That date's going to be. That date's going to be 8/4/22. That's going to be at 9:30 a.m. So discovery will be open through that date. I will also allow, as I typically do, for the filing of motions and setting them for hearing on that date. Such motions, the allowance for hearing on such motions would be an exception to the time that would normally be required under the court rules. So by order of this court, you may file a motion dispositive or otherwise and set it for hearing on the 4th of August, 2022, so long as you give the other party, the opposing party, at least 10 days to respond to the motion. So if you give it a 10-day notification to the opposing party, you can set it on for now hear the motion on the 4th of August, 2022. When you receive a copy of the court's scheduling order in the mail, I'll get it out to you, put it in the mail today. I do wish both sides well. Good day to you.
Thank you, Your Honor.
Your Honor.
Mr. Kim, which matter are you on, sir?
Morning, Your Honor. I'm here on the, this is the Cisco versus Deering matter. This is a scheduled review hearing for this matter. I'm happy to report, actually, the parties have settled it. We're just working out the details. I don't know if you want to put this on the record or not, but we're just waiting to get some more information about who's going to be released.
All right, gotcha. This is case number 21-166-227. This is Cisco Detroit LLC versus Deering Company Incorporated, doing business as Birch Marketplace. And your appearance for Cisco at this time for the record, counsel.
For the record, Your Honor, Albert Kim, P70301, appearing on behalf of Cisco in this matter.
All right, thank you, counsel. Now, counsel, are you anticipating that Ms. Bernard, who represents Birch, will show up, or you guys have already discussed this? So what's going on, sir?
Your Honor, we didn't discuss it. However, in light of the fact that, as I told you off the record, the parties have reached settlement in this matter, I would never presume to make any sort of motion at this point. I think what I would ask is just to adjourn this matter for 30 days to allow us to hopefully finalize the settlement, get the details to the court, and it'll be out of your off your plate.
Gotcha. All right, so I will go ahead, Mr. Kim, with that updated information. I'll go ahead and adjourn it over for review, adjourn the review plan that calls for doing so for a period of 30 days. And we'll set that on a specific date for review. That date is June 15, 2022. And I'm going to set that on 10 o'clock a.m. Obviously, if the parties have settled, they get an order into you, and nobody will have to show up for that hearing. But we will issue a notice for that particular date for review.
Very well, Your Honor. Thank you so much.
All right, good day to you.
Happy Monday, Your Honor.